IA has been filed praying for suspension of the impugned judgment and order dated 19/6/2025, passed by the learned member MECT in MEC case number 54 of 2021, pending the disposal of the MEC case number 19 of 2025. Stop. The appeal has been admitted, and the learned counsel for the appellant prays that the impugned order may be stayed, as there are good grounds in the appeal petition, and there is every likelihood of the appellant being successful in the said appeal petition. Stop. Para. Accordingly, in the interim pending disposal of the main MEC appeal, the impugned judgment and award dated 19/6/2025 is stayed on the condition that the appellant shall deposit 50% of the awarded amount before the registry of this court within 3 months. No, make it within 2 months. Within 2 months. Yes. Application disposed. Yes.
For motion, item number 3.
Your Lordship, this MSc appeal is filed. IN MSc appeal is filed. On the impugned judgment 16/6/2025 in MSc case number 36 of 2023. And my grounds of appeal is in page 6, para 3, 4, 5, and 6, Your Lordship.
Disability certificate not proved.
Yes, Your Lordship.
And another one is income. Similar order, High Learning Council, such the present appeal has been filed under Section 173 of the MV Act, challenging the judgment and award dated 16/6/2025, passed by the learned MECT Dimapur in MECT case number 36 of 2023. So, the main grounds taken by the appellant is that the income certificate has not been proved before the tribunal, and moreover the doctor who issued the certificate, disability certificate, was also not examined, and therefore the disability certificate was not proved in accordance with law. However, without considering the above circumstances, the learned tribunal, right by the impugned judgment and order, has awarded an amount of 56,56,000 to the claimant respondents, with interest at 7.5% per annum from the date of filing of the claim petition. So, hence, being aggrieved, this present appeal has been preferred before this court. So, admit the appeal, call for the trial court records, issue notice returnable within 4 weeks. The petitioner, the appellant, shall take steps for service on the respondent's number
1, 2, and 3.
1, 2, and 3 by registered post, as well as usual process within 3 working days. Then IA is same, stay.
Yes, Your Lordship.
Same order. Judgment and order date will be different, and then state subject to payment of 50%, deposit of 50%. Yes.
For admission, item number 4. 4 and 5.
My lord, item number 4, 5, and 6, my lord. Kindly, your lordship, it was inconclusive item number 6, my lord.
Yes, I was arguing, my leadership, I was arguing, I continue with my arguments. So I was, am I audible, your leadership?
No. 3 of, this one is 3, criminal revision 3 of 25. 3 of 25.
30,
Yes,
30 of 25.
My lord, there are 3 matters now before this court. Item number 4 is of 2025, and one is item number 5 is criminal appeal number 1 of 2025, which was challenged before this court by way of first item of for criminal revision and criminal appeal in both these.
Argued item number 6, and I was replying to item number 6. So let the hearing be over as far as item number 6 is concerned, is my request.
What about 4 and 5? You want to take up
4
today?
4 and 5 after my reply in 6 is concerned, your ladyship. That's it. If we are concerned now with 5, stay has been stay, your ladyship has granted stay on the last occasion.
Yes, we will take up
of
6 also.
warrant.
We will take up 6 also. But 4 and 5, any order you
Kindly look at the order in item 6. Your ladyship may look at the order which your ladyship passed on the last occasion due to
No,
paucity of time.
item number 4 and 5, your lordship will take up later on. Let us consider on item number 6, my lord. Item number 6.
Why I'm saying this is because there is a note, office note, which says that the respondents have not filed additional affidavit in criminal revision 3
Oh, okay, yes. Yes.
So if that's the case, then we can take up 4 and 5 on another date.
Yes.
We'll take up 6 just now. Is that okay?
Yes,
Fair
correct.
enough.
Are you filing the additional affidavit?
We are filing it.
In
We'll file the additional affidavit.
Revision 3 of 25. 3 of 25.
Your Lordship, we have already filed.
Already filed?
Yes, Your Lordship.
We have filed a counter earlier in 4 and 5. We'll file an additional affidavit also.
Can it be fixed on next Monday? This item number 4 and 5 next Monday, 4 and 5
4 and 5.
next Monday. Subject to convenience of my learned friend.
It's okay.
May I request for Wednesday in that case?
Wednesday.
24th. No,
Friday.
Wednesday is division bench.
Yes.
So 20.
Then Friday.
We
Then
only
Friday.
Friday is the
20.
last day.
Friday is the last working
Last day,
day.
that becomes difficult. So if it is on Monday or Tuesday,
Either Monday or Tuesday.
yes.
23rd.
Then 19th is Friday, no?
19 is okay. 19 is then it's okay. Friday 19.
19th.
It's okay. 19.
It's on 19th December on the prayer of the renewed councils for the parties.
Yeah.
That is
Which is operating in item number 4, my lord. That will continue.
Yes, the interim order passed earlier in this
Item number 4, criminal revision 3 of 2.
shall continue till the next date.
Yes.
For admission, item number 6.
Item 6. Yes. Yes, please continue. Item 6.
may I continue?
Yes.
Ladyship, when an accused,
Yes.
when the custody of an accused is required for the purpose of investigation, you arrest him and take him to the concerned trial court or the magistrate and ask for custody under 167 of the CRPC. That's the normal procedure. And if the accused is arrested in some other case, then instead of arresting him, we ask for a production warrant. And is produced before the court because he's arrested and detained in some other case, unconnected with this case, but we want custody in this case. Therefore, we can't arrest him because he's already arrested and kept in some other case. Therefore, we apply for a production warrant. Production warrant is akin to arresting and producing before, something like that, not exactly akin, but something like producing, because without production, remand to custody cannot be granted. Kindly, therefore, have a look at section 167
CAPC.
of the old CRPC, which is 187 of the new CRPC. So the power to remand to custody arises only when is produced. Without producing the accused, he can't be remanded to custody. So if I want custody, if I arrest him, I can detain him for 24 hours, then go to the magistrate and ask for custody. That is remand. But if he's already there in some other case, I can't pull him out of that case by arresting him. Therefore, what I do is I have to apply for production. The accused comes before the court, and then I ask for remand. Now, kindly have a look at 167.
I'm on BNSS.
Then 187 of BNSS.
Yes. Yes.
Procedure when investigation cannot be completed in 24 hours. When any person is arrested and detained in custody, it appears that the investigation cannot be completed within a period of 24 hours fixed by section 58, and there are grounds for believing that the accusation or information is well-founded. The officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate copy of the entries in the diary herein specified relating to the case, and shall at the same time forward the accused to such magistrate. So forwarding of an accused to the magistrate is necessary if I want custody beyond 24 hours if he is arrested.
Yes.
So accused has to be before the magistrate. His presence has to be before the magistrate. In the absence of the accused, in the absence of presence of the accused, the magistrate, in this case the special judge, cannot remand to custody under 187. But if he is not arrested, but is detained in some other case and I want his custody, what is the procedure? That procedure is laid down in, which is that? Which is the new provision in this CRP, in the new BNSS. It is 267 of the old code. What is the new provision? 302 of the
302, yes.
BNSS. Now kindly have a look at 302.
Yes.
So bringing an accused can be after arresting, producing him physically by the police or the ED. That is one way of doing it. But if he's arrested somewhere, detained somewhere in some other case, what is the procedure? I want the custody. So what is the procedure? Bring him before the magistrate, and then argue for custody. Now kindly have a look at 302. Whenever in course of inquiry, trial or proceeding under the Sanhita, it appears to a criminal court that the person confined or detained in prison should be brought before the court for answering a charge of an offense or for the purpose of any proceeding against him, or that is necessary for the ends of justice to examine such person as a witness, the court may make such order requiring the officer in charge of the prison to produce such person before the court answering to the charge and for the purpose of such proceeding or for giving evidence. So what is the proceeding? Investigation. In investigation is a proceeding. It's confirmed by Supreme Court judgment. The recent judgment of Supreme Court, I'll come to that. That is, therefore, he is brought to the magistrate. After he is brought to the magistrate, then ED will say, sir, I want his custody. I want his custody. The magistrate will hear him as if it is hearing a remand application and decide whether to grant custody or not. It is at that stage that he is required to be heard. not at the stage of production. Production is bring him here in this court. PD is asking for his custody. Then we'll give him a hearing, and then we'll decide whether to grant custody or not. Before that, for the purpose of production, there is no requirement of any hearing. The law doesn't contemplate any hearing. Now, kindly look
What
at
is the stage? What is the stage of the proceeding before the trial court in this case?
trial court has issued a production warrant for
No, no,
bringing,
no.
and which has been stayed on the last occasion by your ladyship to be produced on 15/12, that is today.
So investigation is still going on.
Investigation is going on. We have filed one charge sheet, but further investigation is going on. He
Charge
has
sheet.
never appeared, he avoided summons, so we want to interrogate him. He has also been declared a fugitive offender.
Okay.
That matter is pending before your ladyship. Now
Yes.
kindly have a look. One word.
Yes. What else?
Now kindly therefore have a look at one recent judgment of the Supreme Court on this point, 2024, 10 SCC 336. My colleague is there. He will, if anybody is there, please hand over the copy.
Who's producing?
Let that take.
2024 10 SCC.
My ladyship has got the citation.
No, I have not got it.
We have given a list of books, my lord, and it is before the judgment also has been given. List of books.
Now kindly have a look at para 57 of that judgment.
10 SCC. 2024 10 SCC 336.
Yes, yes. Para Sanraj Aswani versus Amar S. Mulchandani.
Dhanraj Aswani. It's here. Yes, page para.
Para 56 and 57. As pointed out, para 56, your ladyship has got.
Wait. Yes. Para 56. Please read. Para 56.
Now, kindly have a look,
Yes.
56 and 57. As pointed out in the preceding paragraph, police officer can formally arrest person in relation to an offence while he is already in custody in different offence. However, formal arrest does not bring the accused in custody of the police officer, as the accused continues to remain in the custody of the magistrate who remanded him to judicial custody in the first offence. Once such formal arrest has been made, the police officer has to make an application to 267 to request the jurisdiction magistrate for issuance of PT warrant without delay. If based on the requirements prescribed in the 267, a PT warrant is issued by the judicial magistrate, then the accused has to be produced before such magistrate on the first date and time mentioned in the warrant, subject to 268 and 269 of CRPC. Upon production before the judicial magistrate, the accused can be remanded to police or judicial custody or be enlarged on bail if applied or allowed. The only reason why we have delineated the procedure followed in the cases where a person is already in custody required to be arrested in relation to a different offence is to negate the reasoning of the Rajasthan, Delhi and Allahabad High Court that once in custody it is not possible to re-arrest a person in relation to a different offence. Where a person in custody is confronted with a warrant obtained in relation to a different offence, such a person has no choice but to submit to the custody police officer who has obtained a PT warrant. Thus, in such a scenario, although there is no confinement to custody by touch, yet there is submission to the custody by the accused based on the action of the police officer in showing the PT warrant to the accused. Thereafter, on production of the accused before the judicial magistrate, Like in the case of arrest of a free person who is not in custody, the accused can either be remanded to police or judicial custody, or he be enlarged on bail and sent back to the custody of in the first offence. A number of decisions have held that although Section 267 CRPC cannot be invoked to enable production of the accused before the investigating agency, yet it can undoubtedly be invoked to require production of the accused before the judicial magistrate, who can thereafter remand him to the custody of the investigating agency. Such an interpretation provision would give true effect to the words other proceedings. Therefore, kindly have a look at this which I am reading. I'll read again. A number of decisions have held that although Section 267 CRPC, which is now 302 of the Sanhita, cannot be invoked to enable production of the accused before the investigating agency, yet it can undoubtedly be invoked to require production of the accused before the jurisdictional magistrate, who can thereafter remand him to the custody of the investigating agency. Such an interpretation of the provision would give true effect to the words other proceedings as they appear in the text of Section 267 CRPC, which cannot be construed to exclude proceedings at the stage of investigation, so and so, so and so. The Lordship of the Supreme Court said that we can apply to the jurisdictional magistrate, in this case the PMLA judge, for producing him. Thereafter, we can ask for remand. There will be a formal arrest and there will be a remand.
So
So
he,
therefore,
he is in custody with regard to another case.
yes. Now I want to arrest him and take him on remand. I can't do it because he is there. So I ask the court to produce him here. I'll arrest him, ask for remand, which is permissible. Now kindly have a look at the. Therefore, production before the court doesn't require any hearing. 267 doesn't contemplate any hearing. If a person is to be arrested, it doesn't contemplate any hearing. No hearing is required for arresting and producing a person before the magistrate for the purpose of remand. It is only thereafter when remand is asked for, hearing is required. Therefore, when my learned friend says I have to be heard before a production warrant is issued, he is putting the cart before the horse. No hearing is required. He is produced before the magistrate. And the Delhi High Court has held, Delhi Special Court has said that he can be produced as and when required by order dated in this very case of this very petitioner, 26 August 25. He was running custody from Delhi. We had brought him here. So Delhi court by order dated 26/8/25 has said that Superintendent Tihar Jail is allowed to produce under trial prisoner Bhupeshwar before the court of learned special judge PMLA Dimapur as and when production warrants are issued by the concerned court. Your ladyship is having that order.
Yes, it was
26 August 25 of the Delhi special judge. That order is in force. That order says whenever the special judge Dimapur requires the custody, he will be produced. That order is binding. That order is not challenged. If it's not allowed to be produced, it would be in breach of that order, which has not been challenged, which has not been stayed.
the order dated 26/8.
Yes, may I read that order?
That order, have you annexed, Mr. Das? That order
He
is
has
not
not annexed suppression.
not
He has
annexed,
not
but
annexed suppression.
yes. But the Deputy Superintendent of Prison, his letter has mentioned it.
Yes.
No, in person. I'll just give a reply. Let him argue. I'll give a reply to it.
Order
I'll give a reply to it.
26/8.
So production warrant is issued. It could not be, he could not be produced on a particular date. But that production can be on a subsequent date also. The court requires his presence. That order, that production warrant has not been cancelled. Therefore, the court, on the basis of the request of the jail superintendent, issued a fresh production warrant. So it is not required that I should apply for a production warrant in view of this order of 26 August, which says whenever the court requires, he should be produced. Court may require it without an application. Kindly have a look at 302. 302 does not require the giving of an application. I gave an application, brought it to the notice of the court. The court asked him to produce. He could not have been produced on the first date. Thereafter, application is not required. 302 doesn't contemplate giving away. Only if you apply, then only he will produce. No, that's not the purpose. That is
So
not the
only after
intent.
production. So you are saying you need to apply only after the production, if at all required,
For custody.
for custody.
For custody.
Yes.
Production application, there is no need to apply. Huh? He is not even on bail.
No, production, no need to apply. That is between the
To
court
apply.
and the jail.
Court can ask for him to come. It can be on my application. It can be suo moto. It can be on the application of jail superintendent. There is no requirement of law that only when ED applies that an order under 267 can be passed, or it can't be passed unless there is an application of the ED. Once ED gave an application, yes, I want his custody, I want his remand, produce him after, because without production there can't be a remand. Am I audible, Your Ladyship?
Yes. Okay.
So he could not be produced, not because of the fault of ED, because there was some problem. Maybe the jail did not have escort. Maybe he was sick, I don't know. Therefore, the jail superintendent said, give another date. The court gave another date and he was produced. That is in compliance of the provisions of 302, which does not require an application. An application is not sine qua non for the purpose of production. It is a requirement of the court. Even if ED applies, the court says, no, I don't want to produce him.
Yes.
Therefore, his entire application that production, his order of production is bad because I have not been heard, I have been required to be heard, is without any basis. There is no hearing required. The law doesn't contemplate any hearing. It's only at the stage of remand if it is remanded to ED
Production,
custody or
yes, hearing is not required, that is clear.
not required, unheard of. Nowhere it is a hearing is made. Even your ladyship may say now Supreme Court has held that other proceedings include investigation. Supposing the police, I'm talking of a general case, supposing police has found out that the accused is in jail in, say, in Maharashtra, they'll go to the magistrate, apply and get a production warrant. No hearing is contemplated. Law and they never contemplate such a thing. It is unheard of. When he is bought, if you want custody, yes. Custody at the time of custody has to be heard, that I concede, but not at the time of production. At the time of arrest also, supposing accused is to be arrested, no hearing is contemplated. No, you have to take the permission of the court, you have to apply to the court and then arrest. That's not the law. That's not the law that for the purpose of production, the accused has to be heard. No. Then your ladyship may kindly have a look at the order of production. Yes, my learned friend has challenged the order of production. That is not an order which initiates proceedings. Kindly have a look at section 507 of the Samhita. Let us assume that it is required to be heard, which is not the law. Assuming that the order is bad because it is required to be heard, that is not what is the law. But assuming it to be so, and such an order may be an irregular order which does not vitiate the order or it does not vitiate the proceedings. Kindly have a look at the type of orders which would vitiate the proceedings under 501. Attaches or sells property, issues search warrant, demands security, discharges a person, cancels a bond. If any magistrate not being empowered by law in his behalf does any of the following things. So in the list up to Q, not wish it, the proceedings are not bad. If the magistrate passes an order under 302, even if he is not empowered to pass an order without hearing him, assuming that it is so, which is not the case, then your ladyship may kindly have a look
Yes.
at 511. Finding or sent 500 Saita.
511.
Yes.
Yes. Finding or sentence.
Subject to the provisions herein before contained. Your Honor. Subject
Yes.
to the provisions herein before contained. No finding, sentence, or order passed by a court of competent jurisdiction. As herein contained, I have shown 507, it's not there. Shall be reversed or altered by court of appeal, confirmation, revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before or during the trial or in any inquiry or other proceedings under this Sanhita, or any error or irregularity in the sanction for the prosecution, unless in the opinion of the court, failure of justice has in fact been occasioned. So assuming that an order can be challenged, then he must show that a failure of justice has been occasioned by such an order. No failure of justice has been occasioned, because failure of justice will be occasioned only if he is remanded to custody, not if he is produced. Now he not only must he show that failure of he must show that prejudice has been occasioned thereby. Unless he pleads prejudice and says this, the prejudice caused to me, the order cannot be set aside. 3 judgments of the Supreme Court on this point. One is Vertigo. Second is Kunduswamy. Have you given the list? Yes. Yes.
It is here in this compilation.
I don't think it's there in the compilation. I can give Vertigo.
Here. This.
Now kindly have a look.
Please mark it, mark it,
Vertigo. Your ladyship is having vertigo?
flag it. Let your colleague flag it.
2021, 2 SCC 525. 2021, 2 SCC 525.
You have not flagged any of the judgments. When you are using the judgments, kindly flag
All
it.
right, I'll come to another. I will come to another point. I'll come back. I'll ask my colleague to give those judgments. I'll come to the next point. Then I'll come back to this point with those judgments. Asking Vertigo and Kunduswamy. Now the next point is, this is an interlocutory order. It's a purely interlocutory order. And there's a bar, which is a new provision for 397.
Ah.
397(2), I'll give the relevant provision as far as revision is concerned in the new code. 438. Section 2. My learned friend has filed a petition under the revision titled Criminal Revision Application. So it must be under 438. If it's filed under the old code, it is 397. If it is 397 of CRPC, subsection 2, which is similar to subsection 2 of 438.
There's a revision, criminal revision. Okay, okay. 397.
438.
Yes.
The High Court. High Court or Session Judge may call for an exam. Your Lordship has got it? 438. Then she was having BNSS?
BNSS, yes.
438.
438. We are not at all familiar with the BNSS sections, you see.
Then come to 397, it's the same. 397 is,
It's okay, since I'm
397 is
having
equivalent to 438.
I'm having the BNSS, 440.
438, 438.
Okay, okay. Calling for records, yes.
To exercise power of revision.
The High Court or Sessions Courts, yes. Please read.
Session Court may call for and examine the record of any proceeding before any inferior criminal court situated within or its local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, or propriety of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, in calling for such record, direct that the execution of the sentence or order to be suspended, and if the accused is in confinement, that he be released on his own bond or bail bonds pending the examination of the record. Explanation is, forget the explanation, kindly have a look at subsection 2.
Section 2.
The powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceedings. Asking the production of an accused is an interlocutory order. It is not a final order. Kindly have a look at
Yes.
one direct of the Calcutta High Court on this point. Two judgments. Probably it is there in the list. One is Anubrata Mondal.
Compilation, it is this.
Compilation
You
first
just
judgment.
you just give the citation. I'll look into it later. You just give me the
I'll
citation.
give the compilation. I've got a ready compilation with the first judgment in the compilation. Who's there giving the compilation? The
Anubrata Mondal.
citation is CRR 840 of 23.
of 2023.
Page 12 of the compilation.
1 to 16, yeah. Page 1 to 16.
One.
Page
Yes.
12, page 12, middle of the page.
This Anubrata Mondal, your ladyship has got it?
Yes, yes. Page 12. Yes, page 12. Production warrant was directed. This one.
Yes.
Yes.
Yes. Please read.
Shall I read that part?
Yes, yes, yes.
Kindly have a
Production.
look.
Which is the relevant portion? It's the second para.
Page 12, kindly come to page 12 of this compilation.
Yes, I am on page 12.
Kindly come to production warrant was issued, directed to be issued by the trial court by order dated so and so, so and so. The superintendent received an email from the additional director ED for execution of the production warrant so and so. The superintendent Asansol Correction Home submitted a prayer before the learned special judge CBI court as seeking permission to execute the production warrant. The said prayer was allowed by the learned judge, which is subject matter of challenge in the instant revision. The case under PMLA is pending before special court at Delhi. Petition has not been produced as yet in the case, said case before trial judge for answering a charge of the offence or for the purpose of any proceeding in the court under whose custody the petitioner is detained on receipt of intimation of production warrant from the officer in charge of the prison has no other alternative but to direct him to execute the production warrant. impugned order dated 2nd March 23 is actually an interlocutory order. An interlocutory order.
And next page,
Learned judge, the learned special judge has no alternative to decide as to whether he should permit this, therefore it is binding. Now kindly have a look at page 13.
second
Paragraph. I have already held that the impugned order dated 2nd March 23 is an interlocutory in nature. Order did not decide or touch upon the rights of liability of the petitioner. Therefore, I am of the view that the impugned order is not revisable.
Next judgment starts at page 17.
Yes.
Next judgment is of Calcutta High Court.
Yes.
Page 20,
CRR 3680.
page 20, last paragraph.
Kindly come to leadership, may come to page 20, last paragraph.
Yes.
The order issuing production warrant, your leadership has got to compel production of an accused before the learned magistrate is absolutely an interlocutory order. And in my considered opinion, is not revisable. If an accused is wanted in connection with a criminal case, he is retained in custody in a jail, correctional home, the magistrate is empowered to issue a production warrant. Section 269 gives authority to the officer in charge of the prison where the accused is retained to abstain from carrying out the court under certain circumstances. That's not the case. If it's an interlocutory order, if it's an interlocutory order, revision is not maintainable. Therefore, challenge to the revision to the production order or production warrant in a revision petition is required to be rejected in limine. Now, I must also point out
Yes.
that here my friend has mentioned 482 also.
482 also.
Yes, but in essence, it is a revision application. It is not a miscellaneous application, which should be an application under, it is essentially a revision application. Now, 482 powers.
Measure is directly on the point. The measure corporate directly on. It is so.
Unit.
Yes, yeah.
Yes.
Now, kindly have a look at
Madhulimai and Girish.
Suneja's case in this regard. Supreme Court. It is not there in the complaints.
This one is not Madhulima.
Now, kindly have a look at Suneja's case, my lord. That is
Madhulimai is there, sir. First.
Suneja, give us Suneja. What is the citation?
2017, 14, 809.
2017, 14 SCC
809.
809. If my colleague has got the copy, you can hand over that copy.
Girish Suneja copy must be in court.
Yes.
Para 38 of Girish Suneja's case. Leadership has got the judgment.
Yes. The judgment is here.
Para
Para
38.
38.
Yes. May I read?
1 minute, 1 minute.
Page 65.
Page 60.
There are 25 now.
Yeah, 25.
Page 65.
No, you.
There are 24, 25.
I'll read para 24 and 25 also. May I read para 24 of the judgment?
1 minute, 1 minute. Yes.
Para
This
24.
second reason.
The second reason why Amarnath is important is that it invokes the principle in the context of criminal law that what cannot be done directly cannot be done indirectly. So what cannot be done directly under 397.2 or 438.2. Therefore, when section 397.2 is same as 438.2, prohibits interference in respect of interlocutory orders, section 482 CRPC cannot be availed of to achieve the same objective. In other words, since section 397.2 CRPC prohibits interference with interlocutory orders, it would not be permissible to resort to section 482 CRPC to set aside an interlocutory order. This is what this court has held. While we fully agree with the view taken by the learned judge that where a revision to the High Court against an order of subordinate judge is expressly barred under subsection 2 of 397 of 1973 Code, the inherent powers contained in section 482 would not be available to defeat the bar contained in section 397.2. Section 487 of the 1973 Code contains an inherent powers of the Code and does not confer any new powers but preserves the powers which the High Court already possessed. A harmonious construction of section 397 and 482 would lead to the irresistible conclusion that where a particular order is expressly barred under section 397 subsection 2 and cannot be subject to revision by the High Court, then to such a case the provisions of section 482 would not apply. It is well settled that the inherent powers of the court can ordinarily be exercised when there is no express provision on the subject matter. Where there is an express provision barring a particular remedy, the court cannot resort to the exercise of inherent jurisdiction. This view has been reaffirmed in Madhulimai when the following principles were approved in relation to section 482 CRPC in the context of section 397.2 thereof. The principles are that the power is not to be resorted to if there is a specific provision in the code for the redress of the grievance of the aggrieved party, that it should be exercised very sparingly to prevent abuse of process of any court or otherwise to serve the ends of justice, that it should not be exercised as against the express bar of law engrafted in another provision of the code. Therefore, it is quite clear that that the prohibition in section 397 CRPC will govern section 480 thereof, and we endorse this view. Now, kindly come to paragraph 38.
Yes.
The Criminal Procedure Code is undoubtedly complete code in itself. As has already been discussed by us, the discretionary jurisdiction of 397.2 is to be exercised only in respect of final orders and intermediate orders. The power under section 482 is to be exercised only in respect of interlocutory orders to give effect to an order passed in the Criminal Procedure Code or to prevent abuse of the process of any court or otherwise to serve the ends of justice. As indicated above, the power has to be exercised only in the rarest of rare cases and not otherwise. If that is the position, we are of the view that it is so, resort to Articles 226 and 227 of the Constitution would be permissible perhaps only in the most extraordinary case to invoke the Constitutional Jurisdiction of the High Court when the Criminal Procedure Code restricts. It is in the interest of fair and expeditious trial for the benefit of the accused person. We find it difficult to accept the proposition that since Articles 226 and 227 of the Constitution are available when accused, these provisions should be resorted to in cases that is not the rarest of rare, but for trifling issues.
There are 29 minutes.
Any event, if such is such,
39, 20.
now kindly have a look at 39 first. In any event, if such a 1 in a million case does arise, only in 1 out of a million case, the appellants can certainly approach the Supreme Court for relief under 136. Now come to para 29 of this judgment. This leads us to another facet of the submission made by the learned counsel that even the avenue of proceedings under 482 is barred as far as the appellants are concerned, as held in Amarnath, and with which conclusion we agree. If an interlocutory order is not reversible due to prohibition contained in 397.2 CRPC, that cannot be circumvented by resort to 482 CRPC, there can hardly be any serious dispute on this proposition. You got those particular.
Okay. Yes. So you're saying that if revision does not lie, then 482 also is not maintainable.
1 in a million it is entertainable. 1 in a million. That too is so. This is not 1 in a million. But they have said ordinarily not maintainable. 1 in a million, that too in the Supreme Court under 136. Then your ladyship may now have a look at those judgments of Vertigo and Kundu Swami. I've sent it to my colleague. I don't know whether my colleague has not available. I'll send it to your ladyship. I'll send those two judgments. The principle is this. If an order is to be challenged, you must plead and prove prejudice. If you don't plead and prove prejudice, your petition is liable to be dismissed. And Supreme Court has dismissed in two matters. I will point out, you have to plead, and the petition does not plead and prove prejudice. And violation of earlier, even under the administrative law, earlier view was that in case of violation of principal justice or audio alterum partem, mere hearing is not given, that itself is prejudice. That view has changed. There is a sea of change as far as the law is concerned. But hearing is not contemplated, hearing is not required, there is nothing. If it's produced, if it's to be remanded, he'll be heard. Now kindly have a look at Tarsim, which my learned friend had relied upon. Tarsim was a case where the accused had cooperated in that part. Okay. Where was the para where it says no cooperation?
Para 32, sir. Of the
Para 32.
That's it. Running page 219 of the compilation.
Running page 219. I had appeared, therefore I know the facts. Kindly have a look at para 32. He was a person who had cooperated. In this case, is not cooperated. Summons was served. He did not appear.
219 of the
There
compilation.
was an order of High Court to cooperate, did not cooperate. Now kindly have a look at Tarsim para 32 on the factual aspects of appeals. Will it be recorded?
Para? Or the factual
32.
aspects. Okay, para 32, yes.
Tarsim Lal.
Yes.
Coming back to the facts of the cases before us, warrants were issued to the appellants as they did not appear before the special court after service of summons. This is not during investigation. This is after service of summons. They did not appear before the court, not during investigation. As held earlier, the appellants could have applied for cancellation of warrants issued against them, as the warrants were issued only to secure their presence before the special court instead of applying for cancellation of warrants. The appellants applied for anticipatory. All of them were not arrested in the filing of the complaint and have cooperated in the investigation. So if you have cooperated, the law is different. But for persons who have not cooperated, the law is different. Therefore, we propose to direct warrants issued them shall stand cancelled. So it is because they cooperated. Now kindly have a look at our case where they have not cooperated. Where is the PC? We have said, where is our case that we said not cooperated? Affidavit or affidavit? Page. If you had cooperated, I would never have asked for enough PC. Of time. Affidavit was sent.
Somewhere it was stated that absconder charge sheet was filed.
Yes.
Yes.
This is another connected.
Connection matter number 4. Where is?
Oh, yes. So you're distinguishing Tarsim Lal by saying that in that case the accused were cooperating. In the present case,
Cooperated. And it's the case of the ED there that cooperative. Here is not cooperative. That is there. Kindly have a look. I'll give the dates. About 6 or 7 summonses were issued. He never appeared.
Page 497 of writ petition
497.
criminal 26.
Yes,
In
I
that-
have. In the other petition, it is there.
In the other petition, it is there.
At page number 497, serial number 29. And he has,
The complaint is filed in writ petition 26. Sir.
that is the PC, that's the complaint. At page 495, the name of the person, name, date of summons, date of appearance. As far as concerned, is shown at serial number 29. And 1, 2, 3, 4, 5, 6. 6 summonses were issued to him: 12/1/23, 23/2/23, 1/5/23, 27/9/23, 18/12/23, and 21/2/24. And he was to appear on 16/1/23, 27/2/23, 8/5/23, 3/10/23, 21/12/23, 22/2/24. He did not appear even on a single occasion. Total non-cooperation. Huh? Even Interpol notice has been issued against him. So Tarsim Lal would not apply. Tarsim Lal says, in any case, Tarsim Lal says you can arrest him, arrest such a person who has cooperated by taking permission of the court. That is para 33.10 of Tarsim Lal.
In this petition, we have pleaded it in our application, that is at page 111. The same fact is pleaded at page 111.
111 of this. Thank you. Give me 1 moment.
Okay. Paragraph 14. Summons dated 13/1/23 Yes.
Now, kindly come to para 33.10 of Tarsim Lal. When in the case of person was cooperated, what does the Supreme Court say?
33.10. Yes. If ED was
If ED of the accused who appears after service of summons for conducting further investigation in the same offence, ED will have to seek custody of the accused by applying to the special court. After hearing the accused, the special court must pass an order on the application by recording reasons. While hearing such an application, the court may permit custody only if it is satisfied custodial interrogation at that stage is required. That application has been filed. Though strictly speaking, not required to be filed in his case because he was absconding, he was not cooperating. Even in the case of a person who is cooperating, ED can take custody. And that custody application has to be made to the special judge with the magistrate for the purpose of remand. And we have made that application. The court will hear and decide whether custody is to be granted or not.
Page 248 of the compilation.
Is to be produced.
Page 248 of the compilation, sir.
248 of the compilation.
That is okay. That is the next step.
Yes, that's the next step. So he can come after second step. If he has not heard of the second step, he can come. I have not been heard. Custody has been given.
But
But
first
not
step-
of the first step. No hearing is required. Interlocutory order, no interference is required.
Yes.
So we have said even hearing be afforded to the other side. So we are saying that after he is produced, hearing will be given to him, and our application for custody will be decided after hearing is afforded. That's all that we are asking. We are saying. And my learned friend is assuming that custody will be given, and then he is rushed to this court unnecessarily, consuming the time.
The trial court may give, may not give.
May
That
not
is-
give. That's it. Lord Lynch is absolutely right. I think those two. Is there anything else left?
Rana Kapoor 184. Hearing is not contemplated.
Yes. Kindly have a look at Rana Kapoor, page 184.
184. Yes. Middle of the page.
Page 184.
Yes,
where it's
184.
selected.
Para 28 onwards may be seen.
The petitioner had challenged, your ladyship has got para 28 at page 183.
Yes, page 183. Yes.
This is again. Petitioner had challenged the order dated 9th August 21, issuing production warrant before this court. Petition challenging said order disposed of by order dated 12th August 21. The said order dated 9th August 21 was not set aside. The special court has rightly observed that the accused petitioner is not a free person. He is detained in person in relation to crime pending before the special PMLA court. When the petitioner was produced before the court, option was available to the CBI to make a request to grant police custody. The court is empowered to pass appropriate orders. Special judge relied on the decision in the case of State Inspector versus so and so. In the said decision, it was observed as follows. In a case where the police officer deems it necessary to arrest when the accused is already in judicial custody in connection with a different case, we now consider opinion there are two modes available to him to adopt. The first one is that instead of effecting formal arrest, he can very well make an application before the judicial magistrate and seek a production warrant for the production of the accused from prison. The conditions required under 267 of the Criminal Procedure Code are satisfied. The magistrate shall issue the production warrant for production of the accused in the court. When the accused is so produced before the court in pursuant to the production warrant, the police officer will be at liberty to make a request for remanding the accused person either to police custody or judicial custody as provided in section 167(1) of the Code of Criminal Procedure. At that time, magistrate shall consider the request of police, peruse the case diary, a representation of the accused, and then pass an appropriate order, either remanding the accused or declining to remand the accused. Thus, even without effecting formal arrest, the police officer is entitled to seek police custody or judicial custody of the accused as elaborated above. I do not find any infirmity in the impugned order dated so and so. There is no breach of order so and so. As that the special judge CB has rightly observed that circumstances to comply with section 41 doesn't exist, etc. That's a different stage. So the law is very clear. He can be arrested even after the production warrant is there, remanded even after the production warrant is there. There is no need to formally arrest also. I think.
Okay.
Mohammad Dawood.
Yes.
Kindly I look at the 43 and 43. Para 43, 49 Mohammad Dawood. Okay.
Yes, what are you referring to now? Which
Page-
judgment?
Page 6.
Para 43. It is there in the compilation, sir.
Yes, page 60.
60.
Allahabad High Court.
Yes.
Kindly have a look at para.
Para 49 maybe.
49.
Taking up the first
First.
submission of the petitioner based on section 267 of the CRPC that a warrant issued under such section does not constitute a detention order authorizing detention in a prison of a person. It would be found that it is fully borne out by the provisions of section 267 except that note as well as the phraseology of the said section indicates that the order in which says therein is an order to produce a person confined or detained in a prison before the criminal court for answering to a charge or for the purpose of proceeding against him. As an order under this section does not partake the character of detention order by the court seeking production for the charge of the proceeding before it. The view finds support from principles laid down in Dharampal, etc., etc. In fact, before us, the learned counsel, the respondent, has also taken the stand that warrant under 267 to be a warrant of detention. He, on the other hand, relies on what he claims to be an order of remand presently passed under Section 309 CR Physical Structure. Moreover, that brings us to one of the main questions in issue between the parties. Indisputably, on the petition being produced by the Supreme Court Central Presence before him, Justice Mohammed has passed the following order: directing detention of petitioner in so and so. That order is accepted. Then para 51, the pro forma custody warrant of petitioner in a decision of Lucknow bench of this court in so and so warrant for intermediate custody, etc. Then kindly have a look at Article 2. Which is the para you want me to read?
You read it. It does not amount to custody warrant.
Doesn't amount to custody. That I've read already. That's all. Grateful, Your Worship. Therefore, my humble submission is that this revision petition may be dismissed or rejected since it's not even admitted. I'm grateful, Your Worship.
Can I respond, my lord?
Yes, yes.
Now, my lord, very important. What my learned friend is saying is totally contrary to what the judgment has been laid down by Supreme Court. Totally contrary. I'll satisfy. Now, kindly see, your lordship has asked one very pertinent question, which I have noted. What is the stage of this case? Your lordship will just recollect. Your lordship has asked, what is the stage in the trial court? The stage of the case. If I'm not wrong, that your lordship has put the question.
Yes,
Now, what is the stage? Kindly see 41 of my petition. 41, page 41. Kindly see page 41 now. What is the stage of the case?
Yes.
This is, my lord, will kindly see MLC number 1 of 2024, dated is 22/3/2024. May I just read this order? Learned so and so special PP for the enforcement director, a complaint under section 45 of the Prevention of Money Laundering Act is received along with the report of investigation in the form of charge sheet for the offence made punishable under section 4 against the accused Mr. Bhupesh Sharma and 298 others. From Bhupesh Sharma is the petitioner. From a perusal of the charge sheet and the accompanying material placed on record, there being a prima facie case, cognizance is taken for the offence of money laundering and the case record is taken into file. Registered this case as a money laundering case number 01/2024. Issue summons to all the 299 accused made returnable so and so. Enforcement director is taking necessary step. So, charge sheet has been filed, prime cognizance has been taken. That's the stage. And from time to time, if your lordship now see page 42, next page 42, time to time, the accused were represented by his counsel. 24/5/2024, kindly see. 24/5/2024, Hemant Shah, second para, for the accused number 1, he was representing through his counsel, and his personal appearance was exempted till time to time. Now, my lord will see all these orders of the learned trial court. All the orders of the learned trial court, 46. Now, we have given separately the compilation. Now, at page 53, kindly see now page 53. An application was filed by the ED at page 53. This is an order, IA 230 of 2024, kindly see, my lord, in connection with that money laundering case. On the top, 230 of 2024, lordship got it? 230 of 2024. This is, my lord, an open-ended non-bailable warrant was issued against the petitioner. Now, at page 55, kindly see page 55.
Yes.
03 subparagraph at page 55. 03 subparagraph. As such, from the aforesaid, I am satisfied that the accused is not cooperating. Kindly mark this, my lord. Not cooperating with the investigation. Lordship got it? Not cooperating with the investigation, and that his presence before the investigation is necessary. And now it is shown that the accused is absconding and stationed in Dubai. Prayer for the application is being allowed. Accordingly, in view of the aforesaid reason as stated, the instant application allowed and an open-ended non-bailable warrant of arrest is hereby issued against accused the Bhupesh, that is a petitioner. With the above observation and direction, instant IA stands allowed and disposed of accordingly. This is an ex parte. We file an application for recalling of this order at page 61. 61. This is recalling IA at page 61.
Yes, yes, we have seen this.
531 of 2024 for recalling of the order, which has been passed on 5/9/2024, date of order, at page 61. Now, kindly see at page 62, Tarsemlal was cited at page 62. Kindly see page 62, second paragraph. Second paragraph. Once cognizance is taken of the offence, punishable under section 4, the special court is seized of the matter. After the cognizance is taken, ED and other authorities named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. The reason is that the accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after cognizance of the complaint under section 44(1)(b) PMLA is taken by the court, ED and other authorities named in section 19 are powerless to arrest an accused named in the complaint. Hence, in such a case, an apprehension and ED will arrest such an accused by exercising power under section 19 can never exist. Now, kindly see, all the judgment was cited at page 64. Kindly see page 64. Page 64, 05. I have considered, my lord, got it, my lord? I have considered rival submission.
You have shown this earlier also.
Yes. See, I want to show, my lord, how Tarsemlal is relevant in this case and how I have been protected by the High Court's order. This is what I want. Kindly see, my lord, in the instant, your lordship has said, in the instant case, accused petitioner was not arrested during the course of the investigation. He was absconding and evading arrest as claimed by ED, but he was not shown as absconder. Be that as it may, ED can still seek custody, even though the accused was never arrested, but after hearing the accused, as per Tarsemlal, as noted above, the application of the ED praying for open-ended non-bailable warrant of arrest was heard without affording an opportunity to the accused. As such, I am of the opinion that the application of the ED praying for open-ended non-bailable warrant of arrest be reheard, giving an opportunity of hearing to the accused petitioner. Application of ED will be reheard on the next returnable date, which is fixed on 18/10/2024, ED to supply so and so. Meanwhile, kindly see that non-bailable warrant of arrest issued against the accused petitioner, namely Bhupesh Arora, is kept in abeyance till the next returnable date. The present on the next date. Now, what has happened on the next date? On 18/10/2024, my lord, 18/10/2024, if your lordship kindly see at page 49. Yes, page 49, 18/10/2024. Lordship got the order, 18/10.
Yes.
Now the accused for Bhupesh Arora was represented by one Amit Singh, accused number 1. Now please turn to page 50 and see the last paragraph. Learned counsel Amit Singh appeared for accused number 1, that is the petitioner, Bhupesh Arora, has apprised this court that application IA number 230 of 2024 is pending disposal, whereby the complaint has filed for non-bailable warrant for accused number 1. The learned counsel submitted that a copy of the IA application has not been served. Learned special PP submitted before this court that the copy will be served today before this court for accused number 1. Let the application IA 230 of 2024 be listed on 12/12/2024. Meanwhile, the interim order IA 531 of 2024 shall continue till the next date. We now kindly see third paragraph. With regard to accused person who has been represented by the learned counsel, their personal appearance has been exempted for today. Issue bailable warrant, so and so. Now, this order, my lord, 1212 was, where 1312 was put to challenge before this court, which I have read, and I am not troubling your lordship again before this court. That is the order of 21 of 2024 that your lordship will find page 76, my lord. I will not trouble. That day I have read the order. This order, which your lordship is in item number 4, has adjourned this matter on Friday. This matter has relevance in this case, my lord. If your lordship kindly see at page 79, see the operative portion of the order. Considering the submission at para 12 made by learned senior counsel for petitioner, prima facie it appears that the order dated 5/9/2024 has not been violated by the petitioner. Hence, till the next date filed, the operation of the impugned order dated 13/12/2024 shall remain state, and a non-bailable warrant of arrest issued in pursuance to the impugned order shall also remain state till the next date. Now, if this order is still in operation, where is the question of my being arrested? They cannot arrest by way of a production warrant. And
We will not go into that, learned counsel, Mr. Das, because basically you are challenging the production warrant. What the court does, what the trial court does,
no,
whether
I
the
will
trial
tell you a
court
lot.
whether the trial court will grant the custody
Manan-
or not, this court is not going into that. That is a different issue.
My
Now
lord,
we are only under protection. Where is the legality of the protection warrant? Whether the court could have that protection warrant
Lord,
or not.
I'll tell your lordship, the
We're only
trial
on-
court, no trial, if your lordship reads the entire tribunal judgment, my
Because-
learned friend, no, it has got applicability in this case, tribunal. They
Because
could not have filed.
just listen to me once.
Yes,
Mr.
yes, yes, yes.
See, charge sheet is filed. Okay, fine. So now the court may require the production of the accused, even if there is no application. Even if there is no application by the investigating agency, the court can on its own require the production of the accused. It may be for consideration of charge, it may be for any other reason, isn't it? So
No,
whether they want the accused for investigation or not, now we will not go into that. Because now you're challenging only the production warrant, saying you're talking about the legality of the production warrant.
yes.
Okay, so even the court can on its own, so moto issue a production warrant. I was the trial court lawyer, the court, so I know every day we're issuing production warrants without any application from anybody.
My lord, can I just respond to your lordship this? I just respond. Now, my lord will kindly see, this is an ED case. My lord, your lordship, I know, my lord, your lordship has an experience of dealing this type of matter. But this is an ED case. How it has been dealt by the Supreme Court in an ED case, kindly look into it. The judgment of the Supreme Court. How it has been dealt. In an ED case, Tarsem Lal, 2024, 7 SCC, page 61. Only one of the paragraph has been read by my learned friend. He should have read entire. Now lordship will come to know what is the effect of this order. They cannot issue any production warrant by humble submission in this case. Because once a
Why
case,
not? Why not?
why not? Because number one, a complaint has been filed and cognizance has been taken. So how the Supreme Court has dealt, kindly see that. Why not, my lord? That's what I am submitting before your lordship.
Yes.
Kindly see, my lord.
Para?
Para, my lord, will kindly see. Para operative conclusion, para 33. Para 33 onwards. The operative conclusion of the finding of the learned division bench of the Supreme Court.
Yes.
Lordship got it?
Operative
Now,
conclusions.
yes. Now we summarize our conclusion as under. Once a complaint under section 44(1)B PMLA is filed, it will be governed by section 200 to 205 CRPC, and none of the said provisions are inconsistent with any of the provision of PMLA. That's right, what the learned court has done it. Even now 33.2, if the accused was not arrested by ED till filing of the complaint while taking cognizance on a complaint under section 44(1)B, as a normal rule, the court should issue a summon to the accused and not a warrant. Even in a case where the accused is on bail, a summon must be issued. 33.3, after a summon is issued under section 204 CRPC on taking cognizance of the offence punishable under section 4 PMLA on a complaint, if the accused appear before the special court pursuant to the summon which is represented by the lawyer, he shall not be treated as if he is in custody. Therefore, necessary for him to apply. However, the special court can furnish bond in terms of section. In a case accused appeared pursuant to summon before the special court on a sufficient cause being shown, the special court can grant exemption from personal appearance to the accused by
I'm
exercising
sorry,
power
may I
under
only
section
interrupt for a minute?
205 CRPC.
In Tarsim Lal's case,
Let me complete.
he was not in detention in some other
Please,
case. He
let
was
me
a free man,
complete.
therefore someone.
Let me complete, Mr. Raju. I didn't intervene. 33.5. If the accused does not appear after a summon is served or does not appear on a subsequent date, the special court will be well within the powers to issue a warrant in terms of section 70 CRPC. Initially, the special court should issue a bailable warrant. If it is not possible to effect service, then the recourse can be taken to issue a non-bailable warrant, and which has been stayed. Now 33.6, a bond furnishing according to so and so is only an undertaking by, now your lordship will leave with this. Now 33.7 is 33.9, 33.9, 33.18. After cognizance is taken of the offence punishable under section 4 PMLA based on a complaint under section 44(1)B, ED and his officers are powerless to exercise power under section 9 to arrest a person shown as an accused in the complaint. 33.10, my learned friend read, I'll read again. If the ED wants custody of the accused who appears after service of summon for conducting further investigation, which my learned friend said, in the same offense, ED will have to seek custody of the accused by applying to the special court. After hearing the accused, the special court may pass an order on the application by recording brief reasons. While hearing such an application, the court may permit custody only if it is satisfied that custodial interrogation at that stage is required, even though the accused was never arrested. My lord will kindly, was never arrested under section 19. However, when the ED wants to conduct a further investigation concerning the same offense, it may arrest person not shown an accused in the complaint. I have been shown as an accused, already filed under section 41(4)(1)B, provided the requirement of section 19 are fulfilled. We are making it clear that we are dealing with the fact situation where the accused shown in the complaint under section 44(1)B PMLA was not arrested in the R case same by ED by excess of power under section 19 PMLA till the complaint was filed. Hence, the appeal succeed and we pass the following orders. We set aside the impugn order, declining to grant necessary bail. We direct warrant issued by special court against the appellant stand cancelled subject to the following condition. Appellant shall appear before the special court within 1 month from today and shall file an undertaking. So, the effect of the judgment is very clear. You want a further investigation to arrest this accused, you have to file an application. Give a particular, there is no question in this case for production warrant. What they cannot do it directly, they are doing it indirectly. Once a complaint is being taken, my lord, once a complaint is filed, they cannot file an application production warrant. What they can do, they can seek custody, but they have to file an application for seeking custody for further investigation. I may not be arrested. What the Supreme Court has said, the accused was not arrested. Once a cognizance is taken, they become powerless. They can come to the court only after filing an application before they learned a special court that this person, we want further investigation. We could not investigate it. Court will give a notice to us, hear it, because cognizance has been taken in this case. Where is the question of filing an application for production warrant? What you could not do it at the time of investigation, you want to do it now, which now you are prohibited by judgment of Tarsemlal. You cannot do it.
So you mean to say that the trial court cannot even issue suo moto?
No, they cannot, with greatest respect, because of a judgment of Tarsemlal.
Why not? Why not?
Why not? Because the judgment is very clear, my lord.
Because he was arrested in connection with a different case. He's in
No,
custody.
maybe
Case.
he is arrested in different case.
In this case, particular case, he was never in custody.
But
So
now,
for the first time, the court wants a production issued a production warrant against him.
the difference is once a cognizance is taken, my lord, here the cognizance is taken.
Yes,
then-
yes.
So there is no question.
Is taken. What about consideration of charge? He has to come
No.
for consideration of charge. Once
It will be-
cognizance is taken, charge sheet is filed, he has to come for framing of charge before.
Yes, that is
court
different.
can always- court can
that-
always issue a production warrant to
That
produce
stage
him.
has not come. That stage has not come. The framing of charge has not come. There are 299 accused. Framing of charge has yet come. It is only a summon has been issued. Now what has happened is that summon was issued. The lawyer appeared on behalf of this petitioner. Time to time personal exemption was granted. Now they file in between application before the learned trial court that issue an open-ended non-bailable warrant against the present petitioner. Court said, in an ex parte order, court said, how can you do it? Because they are appearing, accused is representing through the counsel, through their counsel. Let me
I'm
complete.
called in, just a minute, Mr. Das. I'm called in some other matter in the Supreme Court. May I be permitted to leave? My colleagues will be there, your leadership. Grateful.
Yes. Now, my lord, your lordship will kindly see. That's very, very important. My lord, I do agree. Your lordship is right. In some other cases, yes, production warrant, remand, those your lordship, yes. My lord, with greatest respect, I've got a lot of respect in the trial court. I practice in the trial court also. Remand under 167. Within 24 hours, they will produce before a magistrate. Magistrate maximum 15 days, 60 days, 90 days, but every after 15 days, there will remand. And there has to be a reason recorded why remand is necessary. Now, there is a difference between remand and a production warrant. For the purpose of production, yes, but situation here, if this complaint was not filed, and if this cognizance would not have been taken place, because that will be a pre-investigation stage, my lord, not post-cognizance. Here a cognizance has been taken. So Tarsemlal, Supreme Court says, once a cognizance is taken by the court, then the ED becomes powerless under Section 19. Production warrant also cannot be issued because only what they can do it, because I am representing. I have been represented by the counsel throughout, my lord. Throughout I have been representing. And the court has given a personal exemption. Personal exemption was granted. That like 205. Supreme Court has said, kindly see. It is like 205. Kindly see what the Supreme Court has said, my lord. At page, my lord, 75, paragraph 4.3. Submission. Tarsemlal, my lord. Tarsemlal. 4.2, 4.3. Kindly see the factual, 4.3. Facts. Kindly see facts, 4.3. At Tarsemlal, my lord, 4.3.
Yes.
Now see facts. There is nothing inconsistent between Section 88 of the Code of Criminal Procedure Code, provision of PMLA, on a conjointing reading of Section 4 and 5 with Section 65 PMLA. It is apparent that all the provision of CRPC will apply to proceeding before the special court from the stage of filing a complaint under section 44(1)(b), only those provisions of CRPC that are inconsistent with the specific provision of PMLA will not apply. Reliance was placed upon the decision of this court in Ashok so and so, as there is no inconsistency between section 88 CRPC provision of PMLA. If after service of summons, the accused offered to furnish bond for appearance in terms of section 88, special court should normally accept the bonds. After furnishing the bond, if the accused failed to appear before the special court, recourse can always be taken by special court to section 89 by issuing a warrant of procuring the presence of the accused before the special court. Because the court all the time has said that I was representing, my personal exemption was granted. At one state, ex parte non-bailable warrant of arrest was issued, which was recalled, and subsequently it has been examined by the court and it is stayed. Now kindly see, for 4.4 is most important. Once cognizance is taken based on a complaint, the special court cannot exercise the power of remand, kindly see, under section 167(2) CRPC. After cognizance is taken, the power can be exercised at the highest under section 3092 of the CRPC. So 309, kindly see what is 309 of the 2 CRPC. Remand also, kindly see, it cannot be taken once it is cognizance is taken. My learned friend has argued on 160 remand, but highest under section 3092 CRPC. Kindly see what is 3092 CRPC, my lord, for a moment. Now 4.5. You kindly see 4.309.3092. Now we are in CRPC because they have mentioned CRPC. BNS I look here.
3092.
3092. If the court, after taking cognizance of the offense, in our case, or commencements of the trial, find it necessary or advisable to postpone the commencement of or adjourn an inquiry or trial, it may from time to time, for reasons to be recorded, postpone or adjourn the same on such terms as it think fit for such time as it consider reasonable, and may be by warrant remand the accused if it is in custody, provided no magistrate shall remand an accused to custody under this section exceeding term 15 days at a time, provided further when witnesses are in adjourn, so and so, so and so. So, BNS it will be 346, my lord. In view of this court, kindly see, my lord, 4.4 again, Tarsim Lal. Once cognizance is taken based on complaint, special court cannot exercise the power of remand. 4.4. Once a cognizance is taken based on complaint, special court cannot exercise the power of remand under section 167(2) CRPC. After cognizance is taken, power can be exercised at the highest under section 309(2) CRPC. Now, my lord, kindly see 4.5. In view of this court decision in Satyendra Kumar until, as clarified in the subsequent decision, when during the investigation, the prosecution does not seek the custody of the accused after the court take cognizance, there is no need to arrest the accused. 4.6. When the accused is not arrested during the investigation, after he appears before the special court pursuant to the summons. So I appeared through my counsel. The court did not say that you present the accused. My personal exemption was dispensed. It is not necessary for him to apply for bail. Special court can always take recourse to section so and so. ED. Now, in such a situation, ED seeking remand by taking recourse under section 3092 CRPC, it will be incumbent upon the special court to give an opportunity of being heard to the accused and pass an order according this brief. My lord will kindly see 4.7 as held in second case.
That is exactly what I'm trying to say, Mr. Das.
Yes.
Under 309 CRPC,
Yes.
the ED can always come before the court again, even post cognizance.
Correct.
They can always come before the court, but it is up to the trial court whether to allow or not.
Yes, right. Correct. So, but where is that they have come to the court, file an application? Where is that they have given an opportunity to be heard? They can come today or tomorrow also they can come. There is no problem. The my lord will kindly now go further when they can come. As held by the second case, at 4.7. The CRP is merely a procedural complaint. It is submitted that in case of an offence punishable under PMLA, a complaint under section 44(1)(b) partakes the character of a report charge sheet under section 173 CRPC. Once cognizance is taken based on the complaint, authorities cannot invoke section 19 PMLA and arrest an accused who has not been arrested till the date of the special court taking cognizance. Here is what I am on, my lord. Cognizance taken, now indirectly they want a production warrant from the court for the purpose of my custodial interrogation. So they want an arrest if they require. Now kindly see.
No, it may not be arrest. You see, you continue reading, Mr. Das. See, if
No,
they
if they require,
if they require
if
custody,
there is custody of the accused for further
they can
to file
a supplementary complaint,
supplementary
or
complaint, yes.
they will have to apply to the special court for custody.
Then, my lord, my learned friend said there is no need, all so moto. That's not the proposition of law that we decided.
No. So moto, the court cannot grant the custody, but
Yes.
to apply for the custody. But I'm talking about the production. Your production can be ordered by the court. That much is for sure.
No, production, yes. You can order for production.
Yes.
Production for what purpose?
As far as the ED is concerned, it's up to them whether they want to file this for custody or not. It's up to them.
No, you kindly see production for what purpose? Production has been
For further
purposely
investigation.
mentioned.
If they require custody for further investigation,
No, then what they have to do it? They have to serve a copy to me.
they will. I'm sure they will submit.
No,
it.
my lord, they
want
first
the-
kindly see their application. What is their application?
No,
Their
that is already infractuous and disposed of now.
Which one, my lord?
The application which they had filed for custody,
Yes.
that one which you pointed out to. Yes. So if they want custody, they will have to file afresh.
Oh yes, let them file a fresh.
will have
Where
to
is that they file a fresh? They have not filed any fresh application before they have to file a fresh application.
Just
Under
because they have not filed afresh, why? How does it stop the trial court from issuing a production warrant?
No, then my lord, then this entire judgment of tercel will get nullity, my lord. What tercel? Once a cognizance is taken, my lord will please, my lord, please see the judgment. Once the cognizance is taken. So number one, I'll give an answer. So motto the trial court cannot for production warrant in view of tercel judgment. Yes, in normal course it can, but not in view of the tercel judgment, my lord. So motto it cannot be in view of tercel once the cognizance is taken. That's my submission before this court. Yes, it can. It can. But not in view of tercel once the cognizance is taken, my lord. My lord will kindly see at 5.5. 5.5 of tercel. After cognizance is taken on a complaint under section 44(1)(b) ED has a right to make further investigation, file a supplementary complaint. For the purpose, ED can always exercise its power under section 19 to arrest the accused whom the complaint is filed. But they have to file. Now kindly see this. Now, my lord will kindly see at paragraph 10. Sorry, not paragraph 10. Para 12 was the argument that was made by ED. 12 was the finding of paragraph 7. Paragraph 17 was the argument which was advanced by the ED. By ED. 12 was the proposition. We fail to understand the basis of submission of London AG that after an accused appeared before a special court, paragraph 12, in compliance with the summons, he shall be deemed to be in custody. The object of issuing a summons is to secure the accused presence before the court. It is not issued for taking an accused in custody. This was his argument. Not for the purpose of taking custody. Like a production also is not. An argument is made once an accused appeared before the special court as provided under subsection 1 of section 437, he has to apply for bail. Now this has been answered in paragraph 17 by the learned division bench of the Supreme Court. After carefully paragraph 17. After carefully perusing the provision of PMLA, we find that there is no provision therein which in any matter inconsistent with section 205 CRPC. Hence, it will apply to a complaint under PMLA. A summons is issued on a complaint to assure attendance of the accused before the criminal court. If an accused is in custody, occasion arises for a court to dispense with the personal attendance of the accused. We may note here that section 205 empowers the court to grant exemption only when a summons is issued. Here, when a summons is issued, personal exemption was granted. Subsection 2 of section 205 provides for enforcing the attendance of the accused before the court at the time of trial. If the accused who appeared pursuant to a summons issued a complaint we deemed to be in custody, the lawmakers would not have provided for section 205. Hence, we reject the argument of learned AG that once an accused appears before the special court on a summons being served to him, he shall be deemed to be in custody. Now, this I argued. Then, my lord, your lordship has seen paragraph 20, this 30. From paragraph 30 I read, 31 also I read, and the submission. No, I read the operative submission, operative conclusion also I have already placed before the court. 30, 31, your lordship will kindly see.
31, I think you're
30, paragraph 30. 30 and 31. Paragraph 30 and 31. Paragraph 30. Once cognizance is taken of the offence punishable under section 4 of PMLA, special court is seized of the matter. After taken, ED and other authority named in section 19 cannot exercise the power of arrest of the accused shown in the complaint. Reason is that accused shown in the complaint are under the jurisdiction of the special court dealing with the complaint. Therefore, after the cognizance of complaint under section 44(1)(b) of PMLA is taken by the court, ED and other authority named in the section 19 are powerless to arrest an accused named in the complaint. Hence, in such a case, an apprehension the ED will arrest such an accused by exercising power under section 19 can never exist. 31 is important. We are informed across the bar by the learned counsel of the appellant that some of the special courts under PMLA are following the practice of taking the accused into custody after they appear pursuant to summons issued on the complaint. Therefore, accused are compelled to apply for bail or for anticipatory bail, apprehending arrest upon issuance of summons. We cannot countenance a situation where before filing of the complaint, the accused is not arrested. After filing of the complaint, after he appears in compliance with the summons, he is taken into custody and forced to apply for bail. Hence, such a practice, if followed by some special court, is completely illegal. Such a practice may offend the right to liberty guaranteed by Article 21 of the Constitution of India. If ED wants custody of the accused who appears after service of summons for conducting further investigation in the same offence, ED will have to seek custody of the accused by applying to the special court. After hearing the accused, special court must pass an order on the application by recording brief reasons. While hearing such an application, the court may permit custody only if it is satisfied that custodial interrogation at this stage is required, even though the accused was never arrested under section 19. However, the ED wants to conduct a further investigation concerning the same offence. It may arrest a person not shown and accused in the complaint already filed. So now let us see the present production warrant. So how it was done and how it was filed by the ED. Let's see that.
We have already seen.
Your lordship has seen that
This is,
at page 99, and the prayer is what?
see, the difference here is that
Yes.
you make a difference between persons who are accused only in that particular case. But in your case, the petitioner is an accused in other cases where he is still in custody.
Yes.
That is the
Let us see. My lord, the accused is in custody of another case in Delhi.
yes.
Now, he is also an accused in the case in Dimapur.
Yes.
Right, my lord?
Yes.
Now, cognizance was taken by the court. My lawyer appeared, exemption was granted.
Yes.
It was going on. That at one stage I came to the High Court, and there is a protection which is given by the High Court that my non-bailable warrant which was issued, that was stayed. Now this is admitted position by them also. That means meaning thereby I cannot be arrested. I cannot be arrested by any means.
No, you cannot be arrested when the stay order is there.
But they are doing it.
But-
Divis
but-
they are trying to do
No,
it.
they have not arrested you. They
No,
have not-
kindly see at page 126, what they are trying to do it. This is what my case is about, my lord. Kindly see 126. Kindly see page 126. Kindly see 126.
Oh, you mean the prayer portion?
Yes, they are prepared what they want.
But you yourself said that this petition is disposed of as infructuous.
No, if it is disposed of, then how this 128 order can be passed?
Doesn't remain.
Then 128, kindly see, another order can be passed on 128.
No.
Based
court,
on it.
Court can always issue a protection warrant.
No, that's 128.
It may be unconnected, not in connection with the
But this is in
application.
But this is in connection with 128 only court has issued. Ma, kindly see the learned judge, special judge, is in connection with this infructuous application, my lord. Kindly see, the request was made on based on 128. Kindly see page 128. 128. This was the request which was made. Subject, kindly see, my lord. Production warrant in so and so. IA 465 of 2025. Kindly see. Now kindly see page 40. Kindly see, my lord. Kindly see the impugn order. Kindly see the impugn order. This is what our case is, my lord. See page 40. See page 40 now. Received letter from DSP Central Jail requesting that the court issue production warrant for next day of hearing. Hence, issue production warrant to produce the accused before discount 69. So how Tihar Jail is passing on the basis of page 128, which has become infraction IA subject 465. On IA 465, he is requesting on an infructuous application and on an infructuous order, because if your lordship looks at page 38 on the same date, see page 38 on the same date.
No, but this order of 29/8 is not passed in the in the IA. It is passed in the main case, MLC number 1.
I know, but connection with IA 4, my lord, subject regarding product at page 128. See 128, subject on the last page,
And warrant.
subject production warrant in respect of so and so in case IA 465. IA 465 of 2025.
And what about what is your answer to the submission of the respondents that this is an interlocutory order and
No.
division does not lie?
That's I know, my lord, why he is trying to confuse. We file an application under 482 for inherent part of the code. Inherent part of the code. My lord, kindly see our application. Not only revision. First page, kindly see. Page 1.
Yes, 482 read with 397.
Yes.
It is
It
revision.
is, yes, 482 inherent part of the code. It will still abuse the process of court, number 1. Prevent abuse of the process of any court or otherwise to secure the end of justice. It is not a case of an interlocutor under 397. It is 482, basically. We challenge an order which is infructuous order. Infructuous, my lord, on the basis of 128. This cannot continue. It will amount to abuse of the process of the court if this order is being given effect to 128, page 128. And the order of 29. The order of 29 is given effect to, which is at page 40. Right, my lord?
Yes.
Right, my lord? Now I will show one more judgment which my learned friend has relied. And he has relied one paragraph and your lordship has said whether 267 CRPC, whether an application is required or not. I think that's what your lordship was asking. Whether 267 CRPC, whether any application is required. I said, yes, an application is required. And according to that, you file an application 465 of 2025 on the basis where you ask for a custodial interrogation on the basis of production warrant. Maybe that application has become infructuous. Now the jail authorities has revised an infructuous order. Infructuous, the learned trial court itself, infructuous order. My lord, kindly see I'll show the judgment of the Supreme Court, which my learned friend relied. See page 38 of the revision petition, criminal petition. Page 38.
Yes.
See now, this is the order where my IA was filed, 483. Kindly see the third paragraph. This court has issued production warrant to produce the accused while order dated 4/8/2025 on 11/8/2025. However, on account of Independence Day celebration, Deputy SP Tihar Jail expressed inability to produce the accused on 11/8/2025. Since the accused could not be produced on 11/8/2025, order for production dated 4/8/2025 has become infructuous. So also the present petition for recalling cancellation of production warrant. In the result, the instant application IA 483/25 is hereby disposed of. So when now and at page 40, now the learned trial court says that no, this particular request has been made at page 128. Subject is the same 465. With the learned judge says it become infructuous. Kindly see page 128. Is the same IA subject. See the subject. 128. Regarding production warrant in respect of the accused Bhupesh Zara in case IA number 465 of 2025. One then the learned trial court, with great respect to the learned trial court, one and say that it is infructuous, and on the basis of subject 465, a request made by the DSP Central Jail, and that was allowed to produce on 16/9/2025. Now the question is now whether a fresh application has to be filed or a suo motu. Now I'll give an answer to it where the Supreme Court has made it clear. 2024 10 SCC, my lord. That what your lordship, my learned friend, has shown. 2024 10 SCC, page 336. This is Justice Pardiwala judgment. Dhanraj Aswani.
Oh, acha.
My lord, this is also ECIR matter. ECIR and CRPC, two different offense. 2024 10 SC, page 336.
Dhanraj Ashwini.
Yeah, right. My lord, kindly see on the facts. Because there are two. What is the facts of this case? Para 2 of the judgment, Dhanraj. Paragraph 2.
Yes.
You've got it? A short question of general public importance on which there is great diversion of judicial opinion that falls for consideration of this court is as under. Whether an application for antecedent bail under section 438 of the CRPC is maintainable at the instant of accused while he is already in judicial custody in connection with involvement in a different case. I'll just pause for a moment. This accused, my lord, is involved in an offense in Delhi. Now, he is already in custody of the ED. Now, there is a case, money laundering case, which your lordship has seen in Dimapur. He is already an accused in that case. And he has been represented by the counsel. Non-bailable warrant of arrest has been stayed by this High Court. It is like granting antecedent effect like an antecedent bail has been granted to him. It has been stayed, non-bailable warrant. Now kindly see further at paragraph 3, my lord. This appeal arises from a judgment order dated 31/10/2023 passed by the High Court of Bombay in antecedent bail application so and so, by which the High Court overruled the objection raised by the appellant herein, original complaint as regards filed by respondent 1, original accused, in connection with CR case registered with so and so, punishable under section 406, 409, 420, so and so, and thereby took the view that although respondent number 1 herein may already be in custody in connection with ECI number 10 of 2021, yet he would be entitled to pray for antecedent bail in connection with a different case. My lord will kindly now, I'll just connect it. Now he is being tried in a particular case in Delhi. He's in custody of the ED. Now there is a case which is registered. They want to bring him here by way of a production warrant. Right, my lord? They want to bring him here for production warrant. But in the meantime, he has been protected by an order of the High Court that his non-bailable warrant should not be executed. Meaning thereby, it is like granting an antecedent bail him to him. Don't arrest him. We are staying that non-bailable warrant of arrest. He is in connection in Delhi in a particular different offense. Now he has been brought in a case which is pending in Dimapur court, where a complaint has been filed, cognizance has been taken. I appeared through my counsel. Now at one point of stage, the non-bailable warrant of arrest was challenged before High Court, which has been stayed. It is in item number 4.
Yes, the stay is operating.
Stay is operating. Now it is like granting a non-bailable warrant. Don't arrest. Non-bailable warrant of arrest means your lordship knows in a trial court, bailable warrant is issued, summon is issued, then bailable warrant. Once the bailable warrant could not be executed through the police station, it comes back. Lawyer says to the court, we could not execute. The court said take a fresh steps. Even when he doesn't appear, non-bailable warrant is issued. Now this non-bailable warrant was put to challenge, and there is a stay which is operating. That means I cannot be arrested in that case. Now what you could not do it, you are doing it indirectly by producing me and taking in my custodial interrogation. Now I will tell your lordship, this is what it says in para 3. Para 4 kindly see of the judgment.
Mr. Das, can you just give me the case number, that civil revision item 3?
Yes, case 3 of 2025. Criminal revision 3 of 2025, item number 4.
So,
And order I have annexed here itself. Your order, your lordship will find that order I have annexed here.
yes, it's here.
Yes, 21/3/2020, page 76.
Page 76.
Yes, 76. 76. If your lordship looks into page 79,
Dated 21/3/2025.
3 of 2025, 21/3/2025. See at page 79.
Yes.
Page 79. Consider a submission made by learned senior counsel. Prima facie, it appears order dated 5/9/2024 has not been violated by the petitioner, and still next date fixed. Operation of the impugned order dated 13/12/2024 shall remain state. Non-bailable warrant of arrest issued in pursuant of the impugned order shall also remain state till the next day. Now, my lord will kindly see the judgment again, 347 at paragraph 4 of Dhanraj Aswani judgment, which your lord. It appears from the material on record the respondent number 1 herein came to be arrested in connection with ECI number 10 of 2021. While in custody, he apprehended arrest in connection with CR number. My lord, this is a reverse case. Am I clear, my lord? It is a reverse case. Here, ECR, he was arrested. In Bombay case, he got an antecedent bail. It's a reverse case. While in custody, he apprehended arrest in connection with CR registered against him at the instance of the appellant herein. In such circumstances, he prayed for antecedent bail before the High Court. Appellant herein intervened in the proceeding of the said antecedent bail application, raised an objection that a respondent number 1
here is already in custody in connection with ECI number 806 of 2019. Objection raised by appellant herein in his capacity as the complaint came to be overruled as the High Court proceeded to hold that although respondent number 1 herein may be in custody in one case, yet the same would not be preclude him for seeking pre-arrest bail in connection with different case. Such the objection was overruled. Appeal is now before this honorable court. This is the facts. Now it is a reverse case, my lord. Here, ECR case, my lord, he was arrested in this case. But in a criminal case, in a criminal offense, he got an antecedent bail. So that was a reverse case. Now, kindly see my para 40, 45. My learned friend has read only one paragraph. 45, kindly see.
Para 45 of
45 of the judgment, page 573, para 45 of this Dhanraj Aswani 373,
Kosa.
page
This
373,
It's only till 14.
373. I have given, my lord, to my learned friend.
Volume 11 also.
Next volume.
Oh, next, maybe next volume.
The next volume.
Meantime, volume पर आया मैंने तुम्हें दे दूँगा।
It puzzle हो जाएगा। He doesn't.
आपको क्या नहीं बात late थोड़ी सा है।
No, not this. 2024.
2024,
11 it will be
10 SCC, page 336.
Next volume next
volume 11. The continuation is not there in this.
But by my learned friend, I have given, my lord.
list of books of
Your lordship can see the SCC if your lordship is holding the SCC.
11. It will be there in the continuation. You see, this is only till page, only till paragraph 14. So the continuation will be there.
I think it's a loose island.
next volume पर आना है।
They have not brought the next volume, I think, my lord. If your lordship takes 2024, the book.
This one.
I think it may be in the compilation.
Yes, it's here.
Yes, para 45.
Okay.
Second part में बोल रहा हूँ। ये तो किस
56, my lord, I think my learned friend has there.
56 was read out.
56.
You are referring to para 40.
56, no, 56. Kindly see 56.
Oh, 56 was already read out.
But
Yes.
kindly see that here, I will just point out.
Hmm.
As pointed out in the preceding paragraph, a police officer can formally arrest a person in relation to an offence which is already in custody in different offence. However, such formal arrest does not bring the accused in the custody of the police officer, as the accused continues to remain in the custody of the magistrate who remanded him to judicial custody in the first offence. Once such formal arrest has been made, the police officer, my lord will kindly note down, has to make an application under section 267 CRPC before the jurisdictional magistrate for issuance of PT warrant without delay. So now my lord will kindly see that jurisdictional magistrate, they have to file an application which they have filed earlier under 467. So your lordship was asking whether this police officer has to make an application. The ED had made an application under 267. Your lordship has looked into, but that has become infructuous. Now lordship has gone that the police officer has to make an application of 267 CRPC before the judicial magistrate for issuance of PT warrant without delay. So they have to make an application. Without making an application, it cannot be done. Now, if your lordship looks into para 60 now, see para 60,
1-6.
60,
Yes.
page 60. Now, I am reading this in context with protection which is granted by my High Court, like an antecedent bail. If an accused is granted antecedent bail, which one non-bearable warrant is stayed in relation to offence while being in custody in a different offence, so he is in custody in Tihar, then it say no longer be open to a police officer in the first case to apply under section 267 CRPC for production of the accused before the judicial magistrate for the purpose of remanding him to police or judicial custody. However, it shall be open to the judicial magistrate to require for any other purpose mentioned under the said section, except for the purpose of remanding him to police or judicial custody. So here, my lord, I have been
That's what
protected.
I was trying to say. It can be for any other purpose because now summons are being issued to the accused persons. That means they are being summoned to answer to the charges.
Yes.
Yes.
No. Charges, someone has been issued. Charges, the constituent of charge has not come. The court, my lord, there is a difference. What I am showing this judgment is has to be seen what Tarsim Lal has said. Tarsim Lal, my lord, has made it very clear. Once a complaint is being filed, that means like a charge sheet. It is like a charge sheet. Because in a normal trial, other than ECIR, charge sheet, we said under charge sheet has been filed. Here, complaint with charge sheet has been filed. Cognizance has been taken place like a complaint case. Under 200, 202, 3, 5 and 205, there is a exemption can be granted by the court, as in the trial court. Here, all the procedure has been followed. I have been represented through a counsel where my personal exemption was granted. Non-bailable warrant was bailable warrant, someone was issued. Then the court has issued a non-bailable warrant of arrest to challenge. Then how can you issue a non-bailable warrant of arrest? Throughout my counsel were representing. Court, prima facie, High Court prima facie satisfied, and the non-bail warrant was stayed after hearing the ED. Meaning thereby, there is no occasion for production of the accused in this case also. Physically, VC they can produce. What they can do it? They want my statement to be recorded. They said, okay, under section 50 also you can record my statement which has been done earlier by them. 3 of 2025, they tried. My lord, they tried by filing an application in 3 of 2025. IA 13, which I read, I don't know the trouble. 13 of 2025, your lordship has looked into it. Indirect manner, they said what? They made two prayers. One prayer they said there is some impediment of some orders that has been passed by the High Court, which my learned friend has read. 7/3/2025, 22 there are few orders where the court has said no coercive measures should be taken. Meaning thereby that was the first order that has been passed by this court. Meaning thereby I should not be arrested. So they filed an application before the High Court in Criminal Division 3 of 2025. Their whole case is that they projected that there is no embargo on the ED to arrest an accused under Section 19. Court said there is a reason order. Court said, how can we pass that order? There is a stay which is operating.
Okay, I got your point. So, Mr. Das, what you're trying to say is since the stay order is already there in view of the NBWA, so
Yes.
he cannot be produced for the purpose of being arrested or for the purpose of being in custody. He cannot
Yes.
be produced.
Absolutely correct. That's the pinpoint which this is what the judgment says. Because one paragraph will not do, my lord. So my humble submission before your lordship is that now so my humble submission in conclusion that number one, that this is a questioning application under 482 we have filed. Now we said that will amount to abuse of the process of the court or for end of justice that order which has been passed by the London Special Court on 29/8/2025. 29/8/2025, that was an order which could not have been passed based on an infructuous order. And my lord will kindly see one trouble I am just making at page 116.
Paragraph 26 of their application, which has become.
See 116, my lord.
Go ahead.
116.
Para 26.
Para 26, kindly see. Page 116.
In your petition,
In my petition.
This is
Their production application which they have filed before the learned Dimapur court on 465. See 116, what is their statement which they have made? Kindly see para 26. Para 26.
yes.
That subsequent to above, the accused Bhupesh Arora filed criminal revision petition 03 of 2025, criminal appeal 1 of 2025, along with IA criminal 4 of 2025 in criminal appeal 1 of 2025 in the Honorable Gauhati High Court. The Honorable Gauhati High Court, Kohima bench, by order dated 21/3/2025, state the execution of non-bailable warrant, and wide order dated 7/4/2025, state the FEO, fugitive economic offender, order dated 22/1/2025. However, it is pertinent to mention that Bhupesh Arora has approached the Kohima High Court by filing an IA seeking a stay on non-bailable warrant dated 13/12/2024, issued against him by the Special Court Dimapur. Further, it is stated that Bhupesh Arora has also filed one writ petition so-and-so, where he has assailed the complaint on PMLA and sought questioning of summoning by London Special Court so-and-so. In his event, Bhupesh Arora deliberately and intentionally apprehended a crucial fact proceeding under fugitive economic offender was already initiated pending against him before the Special Court Dimapur. This interim relief granted by the Honorable High Court therefore stands on facile ground, as it was based on incomplete and misleading apprehension by Bhupesh Arora. Further, it is pertinent to mention all these three petitions are pending before Honorable Gauhati High Court for adjudication of the matter. So this 4/8/2025, this allowed. Now all these matters are pending. My humble submission before this court for the end of justice, let this matter, my lord, this 30 of 2025, this order should be extended and it should be placed. Again, your lordship has heard it. 3 of 2025 is the most vital. What the court can do it, my lord? Court can say that your IA 230 of 2025, what we'll do, we'll set aside all this order. 3 of 2025 declaring as a fugitive economic offender. You go before the trial court. IA 230 of 2025-24, which is pending, that will be reheard, because that is an order that has been passed by the London trial court. Because open-ended non-bailable warrant has to be first heard, whether if they were justified in issuing the open-ended non-bailable warrant of arrest, which was stayed by the High Court. Now, if today this production warrant, my lord, they have not given a clear picture before the learned trial court. If learned trial court would have known that all this case, which is now pending before the High Court, that is a stay, the production warrant should not have been issued. Learned trial court should have said that, okay, you go before the High Court, get this non-bailable warrant of arrest, non-bailable warrant which has been stayed vacate, then we'll see it. Your production warrant cannot be on the basis of custodial interrogation. Clear picture was not given before the learned trial court. And your lordship will kindly see all that time they were taking an ex parte order. All the time. Off date, on and off date. If the learned trial court would have known all the facts of the case, he could not have passed that order, my lord. He is not aware of the facts of the case.
Okay, we are in great detail. So
I'm deep, yes.
I'm going to dispose of this today.
Yes.
Heard learned counsel for the petitioner, Senior Counsel Mr. D. Das, assisted by
Aidas and Khalid K. Das, K. Mohammed, Aidas,
and also Mr. S.V. Raju Learned ASG and Mr. Zohaib Hussain, Special Counsel ED for the respondents. So petition stands disposed. I'll pass the order in the chamber.
Yes, my lord, I would be very happy if I would have gone there, but I'm stuck in Dimapur, my lord.
Yes, yes, everybody
I
is.
was mentally, I was prepared. I came Dimapur and
Not only
evening,
you.
I have heard that all is broken. That day on Friday, your lordship, remember, I came back, by chance, I just crossed, then it is broken, my lord.
Everyone is.
Half the way I came back, half the way. That army, that through them, there is some, I think there is a road, another road.
Everywhere it has been washed away. Only one way is left now.
But I don't know, my lord. It will be very difficult, I think, my lord, to open this the main road. I have seen that is all gone.
Yes, yes, it is a very long route, the one which we have to take now through Jaluki.
Yes, through Jaluki.
Another two, maybe 1
4
hour,
hours.
1 hour extra, I think.
I think it will take 3 hours to 3 hours.
3 hours, it may take
3 hours from Dimapur, 3 to 4 hours, I think.
Acha,
Because
the
today
other-
there was heavy traffic also.
Ah,
Heavy traffic.
we have not finished the list, so what to do? You will mention that too, or?
Well, I am deeply obliged, my lord. My matters are over, I think, my lord.
Yes. You can
Your lordship has fixed the matter on Friday. Next two
on
matters.
Friday, yes.
Next two matter. 3 of
Next
2000,
Friday.
3 of 2025.
Yes.
That is non-bailable warrant which has been stayed by the High Court, my lord.
Yes.
But with your lordship,
I'm deeply honest.
my lord, item number 12 may be this thing pass over for the day.
Okay. Item 12 passed over for the day on the prayer of the learned councils for the parties. Okay. Then other items.
Your ladyship,
Yes.
item 15,
Item 15.
that is contempt. I'm representing the respondent number 1. And my friend is, Mosamsa Longkamre is representing the respondent number 2. Now we'll be filing the Bagladama. Maybe within 2 days' time.
Learned Counsel Mr. Mohamchan submits that he will be filing Bakalatama for respondent number 1, and Mr. M. Longkamer will be filing Bakalatama for respondent number 2. And they have prayed for 1 week's time.
2
Just a
weeks'
short
time.
time, Lordship, because after 1 year, the vacancies that was to arise after 1 year, after exhausting 4 or 5 more vacancies, the petitioner, 9 vacancies was to arise. So the Honorable Court directed the respondent to accommodate in that 9 posts that is to arise in one of them.
Let them explain.
Yes.
2 weeks' time, your
However,
ladyship.
And prays for 2 weeks' time to file their power as well as the affidavit. Yes. Stop. List the matter after 2 weeks.
Much obliged.
a fixed date may be given.
So after 2 weeks will be. 2 weeks is vacation, so after vacation.
My lord, in that point, may I rejoin a few points that Dr. Das has said, my lord? Only a few points whenever post lunch or sometime, my lord. Because some
You want to.
My lord, there is no such case like rejoinder in a particular. It will never continue. Sir, rejoinder will never continue.
We have already heard you, reply has been made, so.
That rejoinder is, I have not come across. Sir, rejoinder.
If
Then
you,
again,
want
I
to
have to
give some,
reply.
if you want to give some written arguments or something, you can send it.
we'll give written argument. Fair enough, my lord. We'll give written argument. Obliged.
It's October 6th.
Lordship.
October 6th. Yes.
Much obliged.
Obliged, Lordship.
My lord, 1 day's time to give written arguments, my lord. 1 day's time, my lord.
You give it today?
We'll give it today. Fair
Send
enough.
it today itself?
We'll give it today. By the end of the day, we'll give it.
Yes.
Very well. Deeply obliged.
Then, any more?
We intend to take it up after the break if my lord is willing.
No, because in the morning, the bar office bearers came and informed me that they don't want to take up cases after 1 in the afternoon. You have a bar meeting or
Yes,
something
yes,
today?
yes. We have.
But my lord, only difficulty will be there if my learned friend wants to give a reply, then I have got also a chance to give a
No, not reply, written arguments.
written argument. My lord, then also whether I will give written argument, I also don't know what is written argument. What new point he comes up, that's the only difficulty. What new point he comes up. something very new point he comes up, which I don't know also.
No, he
You can
should
inform-
supply the written arguments then to you also.
And I should get a fair chance to look into it. So Your Lordship wanted to pass an order today itself.
I
Either
wanted
Your
to
Lordship,
today.
yeah, that's why it doesn't accept any of the submission, which is any of the written argument, pass an order.
I will see whether I should accept or not because I've made up my mind already. So we'll see.
Oh, yes. Okay, my lord.
So you want to take up the matters?
It's a short matter, Your Lordship. In
Okay
fact,
then.
yes. In fact, I've matter before court one also. Court one will start only from 2 today. So I'm giving priority to this.
Okay.
Much obliged.
Yes, Mr. Santianger, I think
Four.
we should do it tomorrow. You should respect the sentiments of the bar also, no? The court also, because the bar members, the office bearers already came in the morning and requested the court not to take up in the afternoon.
My lord. All right, then, if that is.
Yes, and you should also abide by the bars. You are also members of the bar.
Yes, of course,
Yes.
of course. But the thing is, we have
No,
waiting
it's
since
not
this
proper.
morning.
It doesn't look proper, no? So pass over tomorrow.
All right.
Pass over for today. Which item is yours?
Item 9, 10, 11.
9, 10, 11. Pass over. Huh? That's all.
For orders, there are two, 13 and 14.
13 and 14. So, these are.
Item
This one
10.
also can be a passover.
In item 10 and 11, there is an interim order. So if it can kindly be extended till tomorrow, anticipated bill.
Okay, 10 and 11, the interim orders shall stand extended till tomorrow. That is
Keep
till
your
the
best.
date, no?
13 and
Then
14.
13 and 14 also pass over.
Uh,
Yeah, or
If orders can be passed, Your Lordship, I have actually taken steps regarding the newly implemented respondent, and I also filed an amended petition. So
both 11, 13 and 14.
yes, Your Lordship. So if this can be come up again after 3 weeks.
Okay. 13 and 14, have learned counsel for the petitioner, Ms. R. Ansela Gibbs, who submits that she has taken steps for service on the newly impleted respondents. So accordingly, list after 3 weeks, awaiting service report on the newly impleted respondent.
Much obliged, my Lord.
Please, Your Lordship.
Yes.
Your Lordship,
The
item 10, 11, Your Lordship, if it can come on Thursday.
Thursday.
Yes, Your Lordship.
I have no objections.
Thursday then, Thursday. And 10 and 11 interim order will stand extended till Thursday, no? Then.
Otherwise, Your Lordship, no objection, there is no objection by the sting also, by the
We
IO
will
also.
pass order on Thursday then.
Okay, okay.
Deeply obliged. Line Kali.
আমি ডিক্টেট কৰিবলৈ আহিব পাছ অভাৰ নাই Charlie,